So I'm very excited to bring to the stage Sahar Ayinehsazia, Cassia Furman, and Mr. Tom Zuber.
Thank you, Mark.
Hi, Sahar.
Hey.
Hi, Cassia.
Hi, Josh.
Good afternoon, Tom.
Thank you, Josh.
So we're all here today to talk a little bit about how to create a brand without a cultivation. What does that really mean? It means how do we legally do these things, and how do we bring a brand to the market without growing the product? These three attorneys here have helped pioneer the legislation and laws around that topic, and I think that after this panel, you're going to be empowered with a lot of the information you need to be able to do that yourself. Also manufacturing, right? The whole piece to it. So what I'd like to do to get this started is to maybe walk through the attorneys here, talk a little about who you are, what firms you work with, and how you've been involved in the cannabis industry up to this point.
Sure, I guess I'll get started
Please
since
do.
I'm immediately adjacent. Hi, everyone. My name's Cassia Furman. I'm a partner with the law firm Vicente Sederberg. We got our start in 2009-2010 era in Colorado, advocating for legalization and fair and effective policy of cannabis, ending the war on drugs. So we were activists first and then became business people and advocates for regulation across the country. We wrote Amendment 64 in Colorado, and from there we're able to launch into servicing the industry all across the country. So our perspective is in California, helping our California clients navigate the new regulations and licensing system, which has been such a challenge for so many people, as well as on a national level, helping some of our clients get introduced to California and have their brands start here, and also in other states. And now we have clients in California who are looking to expand to other states as well. So there's a lot of cross-pollination and a lot of excitement about federal legalization, maybe around the corner somewhat.
It's happening in a couple months, I heard.
We'll see. Yeah.
Thank you. Tom.
Thanks, Josh. Tom Zuber. I'm the managing partner of Zuber Lawler. We're a law firm with offices in Los Angeles, New York, Chicago, and Silicon Valley. We represent a long list of Fortune 500 companies and global funds and government entities. We do the work around the world in languages covering 90% of the world's population. We've also been in the cannabis space for over 12 years, which is a long time, doing M&A work, finance work, corporate structuring, high-stakes litigation, intellectual property, and international work. So that makes us somewhat different as a law firm, and it gives us a pretty unique perspective representing the Fortune companies and representing cannabis companies. Very exciting time. I'm excited to be here with Josh and Cassia and with Sahar, and looking forward to the conversation. Thank you.
Right on. Thanks, Tom. Sahar.
Hi, everyone. My name is Sahar Ayinehsazia, and I'm also an attorney at Vicente Sederberg's Los Angeles office, along with Cassia. My specialties in the field of cannabis really include banking, so figuring out how to establish depository accounts, work with banks to allow them to start to take on cannabis clients, looking at how funds flow works, as well as regulatory, really keeping an eye on the evolution of California's regulations as they continue to change and evolve and hopefully really get to a final point, as well as corporate transactions and what it looks like as far as changes of ownership and acquiring licenses, and really the corporate side of things.
Awesome. How to make the money and keep the money, which
Exactly.
I think is important
Make
to all
the money,
of us, right?
keep the money, and bank the money.
Exactly. So I think one of the foundations of what we're going to be talking about today is how to create a brand without the cultivation, which really is how do we do contract manufacturing, how do we licensing, how do we do white labeling. And as the industry is starting to become more segmented and more expert in each one of these different buckets, the regulations as they change are starting to kind of scare the shit out of everybody. And one of the regulations that had recently changed and was included was 5032B, which really got into white labeling and put a scare across the industry on contract manufacturing and white labeling and the entire segment there. So maybe one of you guys, if not everybody, can talk a little bit about what is 5032B, what's the scare, and how did it turn out, and what should be aware of in that regard.
Sure.
Sure. Well, I'll kick things off on 5032B. I spent way too much time with clients and with colleagues working through this since the Bureau of Cannabis Control released their draft regulations. That, I mean, essentially, it was a clause that was added to the regulations that said that licensed businesses can't conduct commercial cannabis activity with unlicensed businesses. And an earlier draft of the regulation that was ultimately adopted had all sorts of examples of what the Bureau had thrown in as non-permitted activity that would have incorporated, packaging and labeling roles and many other things that people immediately panicked. It was a scary time for folks both who are doing the traditional white labeling, the manufacturers, the brands, and then also ancillary service providers like packaging companies and other folks providing services to the industry. So there was a lot of kerfluffle about the whole thing. The Bureau ended up rolling back all of the specific examples that they gave. So what was left was one sentence saying, you can't conduct commercial cannabis activity with unlicensed businesses with not much explanation other than that, which led to a flurry of, people saying they knew how that was interpreted or didn't. And you had Lori Ajax telling people privately that this is how, we don't mean to prevent and ban white label manufacturing. That's not our intent. And then newspaper headlines saying white label manufacturing is banned in California. And I think, most sort of seasoned folks in the industry kind of took a reasoned approach to that and said, clearly they're not going to ban this activity whatsoever. Like, it's going to be a matter of disclosure. And making sure that the appropriate people are identified as being associated with this organization in the right way. So, that's the approach that we took with our clients and that a lot of other practitioners took. So we sort of went about trying to modify contracts to make sure it was clear that there was, not an unpermissible amount of control, although that was never defined either, and that appropriate disclosures as either owners or financial interest holders were made. So in that whole environment, though, there was a lot of rumor and innuendo going around, and the Bureau was saying they were going to release a guidance document. That ended up coming out a couple weeks ago, and it was, basically said white label manufacturing is not prohibited in California, but that if you have, quote, control over a white label manufacturer, then you have to be listed as an owner. And of course, control is not defined in the bulletin or even discussed in the bulletin,
right,
which is the key point of the entire bulletin. That is the,
And let's even take a step back just to be maybe even super general. How would you define white label manufacturing, just for the people out there that don't know what that quote-unquote term even means?
Yeah, so white label manufacturing really is a brand holder who has IP, who has a brand that they may have cultivated, not actually cultivated, but really grown in another state, and it's well known in the cannabis industry, and they, in California, would be looking to have products, whether it's flower or manufactured products, be packaged under that name so that they could actually have products that are out there on the shelves with that name, but that the brand holder doesn't necessarily have a cannabis cultivation or manufacturing license to produce cannabis or cannabis products.
Yeah, and in California, that included brands in California that were unable to get immediate licenses because of the local government's extremely restrictive policies towards licensing. So it's not just, big companies coming from outside of California and trying to take over the market. It was a lot of people within the state trying to figure out short to medium term solutions to build their brand. They might not have had the capital to comply with the new regulations and build out a compliant facility in an environment that's totally different from what they had been doing for the past, decade or more. So I think it's important to mention it's not just out-of-state brands that are impacted.
Yeah, it seemed like perhaps the intent there was that the BCC would be able to understand who was making money from these ventures, right? Who had some sort of financial interest in these ventures, because we had all these commercial cannabis licenses that were available, but this white labeling thing was outside. It allowed you to kind of play in the middle of all these different things, right? So what's the process these days for listing somebody as a financial interest holder? What does that really mean? And should somebody be afraid of that if they have a license by putting somebody on their license as a financial interest holder? What does that mean to them?
Do you want to take that one, Tom?
Sure. Well, it means different things in different localities, right? So if you're, first of all, it's important to understand that California is a two-level process. So you've got the state compliance component, you've got the local municipal compliance component, and you've got to navigate both, and one is dependent on the other. So really, it varies by location. Ultimately, I think Josh, you stated it very well. Ultimately, the point is that the government, municipal, state, county, wants to know who's involved in bringing cannabis to market, period, at any level of the chain. If you have control of a license, and control really isn't defined, Cassia is correct, so control really isn't defined, but the gist of it, I think, can be summarized as follows. If you're involved in bringing cannabis to market, the government wants your name on record. They want to know who's involved. They want you vetted. They want to make sure that you have a history that's consistent with responsibility. I think the important thing here in this context is really to ask, what do we want the cannabis industry to look like, and what do we want California's role and the United States' role in the global cannabis industry to look like post-prohibition? And from that standpoint, it's important to focus on these things, focus on, okay, who's involved in owning a license and controlling a license and bringing cannabis to market. But it's also important to ask, okay, what are the most valuable cannabis companies of post-prohibition era going to look like? They're going to consist of the companies with the best technology, with the best brands, with the best IP. So from that standpoint, I think it's important to not unduly restrict the ability of innovators, the ability of artists to contribute to the cannabis conversation. And so that's the other side of the equation. To the extent that you are restricting the ability of scientists to contribute to the cannabis conversation, to extract the technological value within the plant, the line between the plant and human physiology, to the extent that California or other states are restricting unduly the ability of artists to bring brands that are associated with a consistency of quality of product across not just retail shops, but across state borders and ultimately sovereign borders. We do a disservice to companies based in California in terms of competing in the global cannabis market. So, thank you. And that is, I think we want to ask here, how can we be responsible citizens in the cannabis community? Our job is really to help the cannabis industry grow up, and we should help it grow up well, and that involves having responsible approaches to these things.
Yeah, absolutely. I think everybody here agrees. And I think one important factor in growing up is developing, protecting, and securing the intellectual property and the assets around the company that you're developing. And that seems especially so in a white labeling situation, because that's essentially what your company is now, right? It is only the brand. So maybe you guys can talk about the importance of development of that IP, the protecting of the IP, and what that looks like here in the cannabis industry at this time.
Sure.
I can take on the trademark side of it.
Please.
A little bit. So trademarks generally work on either a federal level or at the state level. On the federal level, you have the USPTO, which, because cannabis is still a Schedule I substance, you can't really get trademarks for a cannabis or a cannabis product. You can get it for things like smokers' articles or accessories, but really for cannabis products such as flower or manufactured goods, anything that you would need a license for, that's more on the state side. And California's Secretary of State in 2018, January of 2018, started to give trademarks for cannabis goods and services that were done pursuant to license activity and were actually out there in the market on the shelves. So really, when you're thinking about how do I want to protect my brand, it's important to look at, well, what does my brand entail? What does my brand cover? Is it just cannabis services and goods that would only be protectable on the state side, or do I also have goods and services that I could protect on the USPTO side and bring together the federal and the state protections to really lock down my intellectual property to the best that it can be protected?
Thank you. So I'll handle the patent side of things. First I'll tell you all something, that many of you may not know. There's nothing in the federal patent statute, and there's only a federal patent statute, there's no such thing as state patent rights, that prohibits obtaining a patent, issuance of a patent for illegal subject matter. So if anybody here has a process for making better cocaine, I recommend that you patent it because you can. So that's a phenomenal fact when you consider that most people assume that you can't obtain meaningful patent protection for cannabis technology. Let's just eliminate that misconception now. When you talk about brands, it seems to me that speaking in terms of the most valuable cannabis companies of tomorrow, it is almost impossible to have that conversation without talking about the role of technology in building brands. When you look at the best companies of the world, there are real estate companies and other companies, and they can be comprised of things other than IP. But those exceptions aside, it's about technology interacting with brands to grow the value of leading companies. So when you look at a company like a Microsoft or a GlaxoSmithKline or a Pfizer, these are companies that are models for the cannabis industry. The cannabis industry is a technology industry, and most of the industry, permit me to say, doesn't realize that yet, but it is a technology industry. And the sooner that we all here in this room recognize that, and the sooner that we embrace that and we start to live our businesses in accordance with that fact, I think the better off that California cannabis companies are. So to give one example here, when you talk about today, if we open a can of Diet Coke here in California, and then we open a can of Diet Coke in South Africa or in Zimbabwe or in Japan, we have substantially the same experience. We have the same brand experience, language aside. We have the same user experience, almost identical. That's, of course, by design. When you walk into a cannabis shop today and you purchase an extract, and then you walk into that same cannabis shop in that same state a few months from now, you may have a very different experience underneath the same brand. So when you think about, okay, what's required to help the cannabis industry grow up, it's consistency of quality in association with a brand. And then, okay, what's that really mean? What does it mean to have a consistency of quality in association with a brand across not only the same retail shop within the same state, but across state borders and sovereign borders? You're talking about precision. You're talking about precision of process. You're talking about controlling the process from the moment the seed goes in the ground, and even before that, when you're creating the seed, all the way to the consumer experience. And so owning every portion of that process is vital to controlling the quality experience in association with brand. That is what it means, in my view, and I think in the view of my fellow panelists too, to help the cannabis industry grow up. And so that involves, as an example, plant patents and strains. Right? How can you, as we embrace the notion of recreational status of the cannabis industry, that's well and good. But ironically, we're going to move back to medicinal, a focus on medicinal in many respects, because most of the money is medicinal. When you think about what you'll pay to get high and what you'll pay to help cancer, there's just no comparison as to value of that plant and how much you'll pay for that product. So we will divert our focus back to medicinal. And when we start talking about medicinal products again, we're talking about controlling the quality experience. We're talking about precision, including, as one example, the strains associated with that brand. So that involves plant patents, as an example. So Josh, I hope that gives some semblance. It's an awfully big topic.
Yeah, I think it does. Yeah.
Give a summary of that.
Yeah, I'd just like to add, we work with a lot of brands that think they own their brand. And I think the identifiable fact is saying, what the fuck do you actually own is what trademarks do you have, what domains do you own, what Instagram handles do you control, and what are your assets in a company. If you're not building your company and your brand, even if it's white labeling, to be acquired by somebody, you're not actually creating value. You're creating a movement that is not enforceable. Now that's the second thing about what I want to say is that if you're going to create a brand and you're going to develop IP, you're going to sit with lawyers and be counseled and spend money on developing these brands, which I highly recommend you do, you need to be prepared to enforce against them. The cost to do so far, far, far and away outweighs the cost of getting the brand. But if you're not prepared to enforce against that brand, then the value of owning it does you no good. And maybe you guys can talk a little about your experience in enforcing IP in the cannabis industry, if you've done that at all, and what the costs and what people should be prepared to do for as they build this brand and they need to be able to defend it.
Sure. We are involved in a number of intellectual property litigations, some that you've heard of. It's actually easier to talk about litigations we're not involved in, because obviously you don't want to make statements on the record while your clients are involved in litigation. But one thing I will say is that our law firm does an awful lot of litigation, including inside and outside of the cannabis industry. That's trademark and patent work. But it is exciting in the sense that brand litigation and patent litigation, they're going to take a more and more and increasingly prominent role in determining the landscape of the cannabis industry. One example that I'll talk about, because it's not our case, relates to the recent patent litigation filed in Colorado. If you're not aware of it, it's United Cannabis Corp. Versus Pure Hemp, and it relates to a CBD patent owned by United Cannabis Corp. And this CBD patent, it ostensibly, on the surface of things, gives United Cannabis Corp. Ownership of any CBD product, the right to create any CBD product where the total cannabinoid content is 95% or greater CBD. That's a broad patent. I'll say that again. The patent claims any product in which the total cannabinoids consist of 95% or greater CBD content. That's a lot of cannabis CBD products out there. On the one hand, that's a scary patent, right? Because it looks like it involves many of the products out there. That's a test drive for United Cannabis Corp. They're really testing out this patent to find out how it does. Based on how that litigation goes, you're going to be hearing more about this patent. So it does make sense to focus on the role of intellectual property in all of our lives, in the way that we're going to operate our businesses as we proceed toward the end of Prohibition. Another thing to keep in mind, too, is that as we think about where the cannabis industry is going, we may entertain the notion that perhaps the isolation of cannabinoids is really not where the technology lies, not where the primary value proposition lies. There's an awful lot of technology within the plant, the way that the cannabinoids interact with each other, the way that those interactions affect the receptivity of various cannabinoid receptors in the human body. And so technology, a lot of the technology lies there. So perhaps in the future we'll find out that the major patents actually speak to the interaction between different cannabinoids and not to the isolation of a particular cannabinoid. So there's an awful lot on that topic too. I'll speak generally. I mean, the trademark litigation, many of the important ones were filed or involve my firm, but I can say in a general sense that some of the major brands that you're aware of, they're really starting to assert their rights relating to the major cannabis brands in the United States. That's going to increasingly be the case, and you're going to see brand wars and patent wars occupying your view increasingly as time goes on.
How are you seeing the valuation of the companies in a market where everyone's talking acquisition or some sort of M&A transaction? How are you guys seeing the value of the companies affected by either a lack of IP or the fact that they've put that together already?
Well, I mean, it's a bit of a crapshoot currently. There's been a real buying spree, as I think most people are aware, and probably a distinct lack of diligence around what the assets of the companies actually are, and more of a focus on obtaining and rolling up licenses to show that you have an extensive portfolio of either brands and or retail locations or both, whatever the case may be. But I mean, that window is finite, and that in some cases is funny money that is not going to be around forever in such a easy capacity to get. And as the market matures and as the companies, more companies go public and are better financed, that's going to be increasingly critical.
Right, the values are going to start to normalize as people see through the windows of speculation into what the companies really are.
Yeah, definitely. And I think just to take things back a little bit to the challenges of building a brand and finding that partnership to help, white label. There's a lot of technical aspects about protecting your intellectual property and making sure that you have the right contractual terms and enforcing your intellectual property via monitoring your trademarks and patents to see that others aren't infringing on them.
Because essentially you're giving them the IP, right?
Yeah, you're giving them your IP, and there's some fundamental questions as to whether that IP can even be defined and whether these contracts are even really feasibly enforceable when you're talking about something like I'm going to bring my, my seeds and grow my own strains at your facility. These are my processes for manufacturing this product, but I don't have anything but a trademark on it. And so finding the right partner that's somebody that you trust and who's also technologically capable of producing your products to the same quality that you would make them yourself has been a huge challenge in California and in other states, but especially here as things have just opened up recently and there's more companies getting to this sort of higher level of manufacturing production capacity. So right off the bat, finding someone who is trustworthy and who has a track record has not been easy, and you can set yourself off on the wrong foot pretty quickly without even respect to all of these other very technical, very important things to do if you don't do diligence in that respect.
Yeah, and that's a somewhat difficult task, right? Because contract manufacturing, due to the fact that this regulation hasn't been really clear, has only existed for a handful of months. So to be able to identify yourself as a contract manufacturer or a co-packer in the cannabis industry is something that's less than a year old. So how do you vet these companies and how do you really make a good decision? And I think it's just spending as much time as you possibly can with them and looking into who their sales and manufacturing staffs are. Go to their site, see the kitchens.
See what they actually have set up, because a lot of companies have big visions for, we're going to have this production capacity and we're going to have this equipment, but that equipment is expensive to set up and it needs to be signed off on if it's, volatile manufacturing processes, and that takes time. And a lot of folks have, plans to get to where they want to be, but when you start getting into the details, do they have the market share, and is the equipment actually set up and functioning, and do they have anybody that knows how to run the equipment? Is kind of another story.
100%. Okay, so slightly switching gears here. It sounds like now we have the right in order to do contract manufacturing. We've built the brand and we own the IP. And now we're transitioning into, now that we have the IP and we found a manufacturer that can make it for us, what type of packaging do I put it in? What are the regulations around that? And how do I get something out that's child resistant and tamper evident and all these sort of things? And when are these deadlines? And rather than jumping into the details around that, maybe you can give us an overview.
Just send an email to the MCSP.
Yeah, exactly.
Yeah. I got an amazing
the labyrinth that
from
is
them.
packaging, right?
Yeah.
Well, that's if you're asking for a bigger picture perspective first. I think it highlights the challenges of building brands, white label brands or not, across state lines, because you have regulations that vary. So you can't, even in the United States, across two different states, you can't maintain a consistency of packaging in the way that you can outside the cannabis industry. So that's a real challenge. They're multi-state operators. They face this challenge every day, and some multi-state operators face it better than others. It's an opportunity too, though, because it is possible to navigate this landscape, and it is really the basics for the cannabis industry right now. It's consistency of quality and consistency of user experience across a brand, across geographical zones, and that's really a succinct task, I think. In the context of packaging and labeling, the idea here is to find out, okay, what are really the key elements of your theme artistically, aesthetically, with your brand? What is the goodwill that's associated with your brand? What are the key elements of that? What is it that folks see in your brand? So I think as we move toward post-prohibition status, we're going to see less of an emphasis on words like that involve a play on cannabis or a leaf included in the logo, in the name, and you're going to start to see what's called fanciful brands, right? So when you think about the biggest brands in the world, like a Nike or a McDonald's or an Apple, these brands have something in common, a common denominator, and that common denominator is that none of those brands, none of those trademarks have anything inherently to do with the associated products, services that are sold underneath those brands. Think about that. Those are the most powerful brands in the world. That is not an accident, because it's impossible, I think almost mathematically, to build one of the most powerful brands in the world when you're not dealing with a fanciful mark. because that fanciful mark, part of the power of it is the fact that it is not related in the first instance with the goods or products associated with it. So then you come back to, okay, what is it about a brand? And what is the story behind a brand? What is the user experience that you're communicating to a first-time user? And can you capture that across state lines as you're dealing with these packaging variations, these packaging compliance variations? And that's, I think, a navigable terrain.
Yeah, I think you hit on something very important there, and even when you were speaking earlier, it's the fact that these brands are building trust with the consumers, right? It's trust that there's quality, it's trust that the packaging, it's trust that when I see that thing there, that I know my experience with it is going to be consistent across the board.
Yes.
That's something that I don't want to say I've seen to be impossible so far in the U.S. market, but it's been a very, very difficult task because of the packaging regulations, because of the co-packing regulations, because of all these things. Have you guys successfully seen anybody make that transition or be building in that manner, and what kind of thoughts do you have on that?
I mean, I think just kind of hopping off what Tom said as far as building your brand with your packaging is that even within a single state, it's a willingness to evolve with the regulations just in that state alone. Because in California, since I would say middle to end of 2017, we've had multiple different variations of packaging regulations which require brands and require licensees to be able to quickly evolve and adapt, whether it's placing a universal symbol on a different part of a label or a package. And it's really brands that are able to quickly understand how to involve evolutionary regulations into their brand and how to continue to build brand recognition even when within a single state their own packages, their own labels have to maybe change around and kind of grasp what the new regulations that are coming out are. So it's having foresight of how is my package, how is my label, how is potentially the way that my IP is used going to have to be changed as regulations are being nailed down more and more.
Yeah, I think that's extremely important, Sahar, and that plays into a lot of the brands deciding how many SKUs you have, what type of labeling structure you're going to have, what type of boxing and packaging structure you're going to have, what type of inventory you want to house for all these different color boxes you're going to have, and in the end, how much of that stuff you want to throw away when it doesn't sell, right? So there's I think planning that needs to go into every part of that structure, and it's all relying on the regulations. We have three of the best minds in the country here to talk about it. Do you guys think the regulations are going to change at any point?
Yes.
Yes, 100 million%, right? So
yes.
What I would recommend, I think probably is the recommendation from everybody here, don't buy 1 million units of anything yet, right? I think the goal right now is short runs, knowing that there is going to be changes happening in the immediate future. The state, at least here in California, has already put us onto that fact. And I think in most jurisdictions of the world, whether it's patient advocacy, doctor advocacy, company advocacy, there are groups that are pushing for change in every direction. And I think most of the governments are listening and making changes in positive directions. But the reality is we don't know where they're going.
Yeah,
So,
I just want to add a practical tip on like building trust that you talked about and sort of brand awareness from the perspective of like developing a reputation as a reputable, trusted operator. The state basically made in California, distributors and retailers jointly and severally liable with manufacturers for packaging. So they have to provide a quality assurance check of the packaging when it comes to them, and they're watching. I mean, the reputable distributors and retailers are sending back packaging and labeling stuff on pretty minor points that aren't compliant with state law because that's what they think they have to do. So if you're paying attention as a manufacturer or as a brand and making sure that your products are on point, they're going to see that and respect that, and it's going to help keep your products flowing to the stores and to the distributors if they don't have any problems with you.
totally.
One of the things that I have seen, a creative approach to building brands in this context, is really using CBD, right, in the context of the Farm Bill to grow a THC brand.
Because you can put it out
because you can
Further
put it out there nationally with fewer restrictions on packaging. And the notion is that they're building a brand in association with cannabinoids in general, and then they're going to leverage that, use that as a bridge in each state in which they're not currently selling THC to sell THC later. And I think that that's a smart and I think potentially a fruitful approach.
Just don't make any health-related claims.
100%. 100%. Okay, so we're going to open up to Q&A, but I want to do one more question here before we do. We can make the product, we can white label it, we can sell it, we know how to package it now. Sahar, how do we keep the money?
So as far as banking goes and keeping the money really goes, one of the most important things, if not the absolute most important thing, is to be transparent and to be honest with the financial institution that you're going to. Generally, state-chartered financial institutions, especially credit unions in California, have been more willing to take on cannabis-related businesses. If you are a brand holder and don't actually hold any licenses, a lot of the time you are looked at just about the same way as a licensed cannabis business is by a financial institution. In their eyes, you are still bringing in proceeds of federally illicit activities. So it's important to make sure that as a brand, if you're trying to get banked, you're working with the best possible operators, that they have all of their T's crossed and their I's dotted, that you are able to give assurances to your financial institution that, hey, I'm not collecting proceeds of state illegal activities. What proceeds I'm bringing into you are because I work with licensed operators, even though I'm not a licensee myself, and really be willing to respond to all of their questions and respond to all of their requests. As a cannabis-related entity, you're going to be asked for more information, more documents than a quote-unquote normal business would be. So just be really willing and open to work with the financial institution that's trying to get you banked.
Anybody else on banking? I think you covered it. Okay, let's open it up for some Q&A.
Hi, everybody. Hello?
Hello.
Hello. Thank you guys for joining us, and thank you for your time. Just a quick question about percentage of ownership. I know you briefly touched on you could technically white label, but you can't have any control over the company, like quote unquote. So for those like trying to actually exert control or like want more of an active role, you have to be like an owner operator. Is there an actual like percentage limit of what you need to own? And then also like, how are you kind of seeing some of the fancy footwork being done in the industry, not just on the manufacturing end, but like people trying to get licensing and can they get 1% of that business and all of a sudden now, they could own and operate and et cetera, et cetera. So.
Yeah, so the threshold, the state defines owner to mean 20% or more interest, but it also includes officers and directors of a corporation, the manager of an LLC, the CEO of the company, as well as individuals with management and control without really defining that. And up until this whole white labeling thing started, the Bureau wasn't really that receptive to naming like store managers or people who have on-site management of the operation as having control and being an owner. We got some feedback from them to that extent at least. So, I don't know if that answers your question to the threshold, but anybody with 20% interest or more is an owner. And as to fancy footwork, there's plenty of it out there, but the state requirements for disclosure, especially from the Bureau in particular, as opposed to MCSB and CDFA, are now, a look through to multiple entities. So the fancy footwork is going to probably involve not disclosing what they're asking for. So.
Yeah, and one thing that Cassia just glossed on that's so super, super, super important is that her and the firm and a lot of the representatives, I'm sure Tom's firm as well, are in direct communication with the BCC on these issues. So when there is some cloudiness around it, there is conversations happening and clarifications happening. That's something that can occur here.
Hello.
Yep.
Thank you all for your time. My question's in regards to post-prohibition. We're all looking at the States Act very nervously this year and seeing and anticipating its passing. Could you guys describe what the landscape looks like for access to institutional capital in the United States and the ability for companies to possibly list on United States exchanges post-prohibition?
So, first of all, to start, for folks who don't know, there may be some confusion about can you or can't you go public, because this company's public in Canada, that company's public in the U.S. The general, and it's a broad line rule, is that if you touch the plant, if you touch cannabis in a country in which it's prohibited, you can't list on certain exchanges. So you can't list on the Toronto Stock Exchange, you can't list on the American Stock Exchanges, the major stock exchanges. You can list on the CSE, the Canadian Stock Exchange, and other stock exchanges. So that's really the broad line rule here. And so what you see, ironically, is you'll see a Canadian company that's touching the plant in Canada listing just fine on a U.S. stock exchange because they don't violate the cannabis laws of any country. So that's an irony that plays out. You can also see companies that are based in the U.S. Going public in Canada on the Canadian Stock Exchange. What's happened as a function of prohibition in the U.S. is that really we've developed three capitals of the cannabis world. You've got Israel, Tel Aviv, which is the capital, I think, of the technology portion of the cannabis world. You've got the United States, and particularly California, right here. It's the capital of the cannabis world in terms of culture and also in terms of market. And of course, Canada is the capital of the world in terms of finance. It's a huge disadvantage. So I think what's going to happen is I do believe that, like Cassia and I'm sure Sahar, that there's a lot of compliance change in the future. I think Trump is going to deschedule. And at that point, the American stock exchanges will open up to cannabis. I think Trump is going to deschedule because he's going to make a calculated assessment. I'm not going to lose my base on the one hand if I deschedule, and I'll gain some votes from cannabis voters that wouldn't otherwise vote for me if I do deschedule. And I think that simple analysis will cost Trump, whatever else he is, he's got good instincts when it comes to appealing to voters. He's going to make the decision to deschedule sometime closer to the election. And when he does that, the American capital markets will open up. It's not as soon as it should have been, but it'll be a breath of fresh air. And at that point, American cannabis companies will just have a lot more ability to really stake their claim globally. So right now, Canada is all out in front because they've got the money and they're purchasing assets throughout the world, and the United States can't compete to the same extent.
Well, and they have the money because their federal government opened the gates, is what we're saying, right?
That's right.
They opened the gates, they allowed federal legalization, that allowed them to develop a speculative market value on the cannabis industry,
That's
which
right.
allowed them to have $500 million market caps, which then allowed them to acquire a large segment of the United States cannabis market. So I totally agree. I don't know on the timelines there. I think you would know better than any of us. But I think we need some sort of reactionary measure to help counterbalance what's happening up there.
Yeah, contribute to Cannabis Trade Federation and other organizations that are working to get this done in D.C. right now, every day with the States Act and with other important bills. We're closer than we've ever been. I don't know that it'll be this year, but probably not, but it's going to be soon. Yeah. And we've got bipartisan support behind these efforts, so it's an exciting time. Yeah. It's going to take some time, though, to develop. It's not going to be overnight, and it's going to be a different landscape than Canada.
100%. Next question.
First of all, thanks to the panel. Josh, I want to open this up to you as well. I believe something that you said was very pertinent, that we're technology companies who just happen to be in the cannabis space. With that being said, a lot of the goodwill, intangibles, IP, that off-balance sheet stuff will really account for a lot of the big valuations going forward. With that being said, in launching a brand, single-syllable domains are hard to come by, and if so, they're super expensive. With that being said, what recommendations might you have on a longer domain or a different extension, and what kind of costs would you feel comfortable with investing into that, knowing that long-term, especially when it comes to e-com, that's going to be really a high selling point for your brand?
Yeah, I'll take that a little bit. You know, I think the length of the domain, traditionally a 3 to 5 letter domain, is always going to be the easiest to remember, easiest to input, and the most successful. That being said, that's in an industry where the domain is inputted on a very regular basis, and you're finding that through like some sort of search engine or search unilaterally on your own. In our industry, the platforms that are successful in doing that don't allow us to market there. So the domains have not traditionally held a ton of value, but for the fact of being a placeholder to say, this is where my brand lives, this is where our content can live, and this is where it really helps to round out my brand portfolio. That being said, last week I had a conversation with somebody who said, I think it was pot or edible or weed, one of these top 5 terms that you would own. And they were asking my business partner, Gary Vee, how much should we anticipate to spend on this? And he goes, well, is it 5 or 6 figures? And it was less than that. And they go, okay, we should buy it. Because the reality is none of these terms, even at the astronomical price that they're asking for, have realized their true value as of yet. And they will be the foundation of billions of dollars of industry if that potential is fully realized. So it really depends on what you do with it, right? Next question, guys.
Hey guys, great panel, really informative. I'm really interested in this idea that there's going to be the assertion of IP and that companies are going to spend a lot of time, money developing products, developing sales channels, developing market share, and then to be forced through some sort of injunctive relief to get their product off the shelves. And I'm just trying to understand what the probability in the minds of the panelists are that, for example, UCC could actually build a firewall around any hemp-based CBD product that has 95% contents. That's a scary thought. That if that actually became a firewall where unless you deal with their IP and, if you will, pay them their fee, they can essentially stop the development of the industry. And this invites the possibility of patent trolls, of venture capitalists funding spurious patent litigation. And here we are on the cusp of one of the great, entrepreneurial ecosystems of our generation, like unprecedented. And it's a horrifying thought to me as a financier and as a participant in this industry that it's going to get derailed or curtailed by the assertion of protective IP. And one of the things we've loved about this industry is sort of the lack of moat in the sense that the whole category was generic to begin with in the pharmaceutical sense, which is clearly not what seems to be happening. So to put you guys a bit in the prediction business, Tom, you've already predicted when Trump's going to unschedule cannabis, so I'm going to keep your feet to the fire on this, but is this a remote but possibility, or is this, holy shit, get ready, because here comes a IP development that is going to be so disruptive to virtually every business plan that I've seen, heard, or participated in, that it's almost like a reset on where our industry is? Thank you.
Litigator?
Happy to take that one.
Yeah.
Thank you for the question, Paul. So, on the surface of things, it looks like a holy shit moment. I submit to you that it's really potentially not. The important thing is advice. And I'm going to speak for Cassie and Sahar, I'm certain, and I speak for myself. None of us is offering any legal advice here, and I'm not doing that now. It is, ostensibly, theoretically, it's possible to design your products around that patent. Again, let me make a statement. I don't want to talk about that patent and that particular patent holder, but I think that a number of the patents that we currently celebrate in cannabis, we're celebrating because they were first, not because they're going to be the key patents post-prohibition. To state it another way, I think it's possible that 5 years from now we'll look back at some of these patents and say that's kind of antiquated. Again, I think that our understanding of what's going on inside that plant is nascent. We haven't had the best minds on it as a function of prohibition. That's a huge opportunity, but it also instructs the answer to your question, Paul. I think that that it's possible, for instance, to create. Let me state it even more strongly than I was going to. I was going to say that it's possible to create a product that does not infringe that patent. I'm going to state something. I'm going to make an even stronger statement. I believe that the products that you want to put on the shelves, the best products, by definition, will not infringe that patent, because I think that patent potentially misses the point, because it's isolating a cannabinoid. And I think that, for instance, if you've ever used a CBD product and it's just CBD and you've given it to your mom and you and your mom say, well, I don't feel anything, there's a reason for that. Because the CB2 receptor doesn't receive CBD well in the absence of other elements of the plant, including not only the cannabinoids, but the terpenes, the ballast, and other biochemicals within the plant. So I believe that the most valuable products tomorrow, the most effective products of tomorrow, will consist of other cannabinoids. They will play crucial roles in the user experience, in the uptake by the cannabinoid receptors within the human body. So I don't know that that's the patent I would focus on. But that doesn't mean that you shouldn't, talk to an attorney about making sure that your current products aren't going to get yanked sometime in the near future after this litigation plays out in Colorado.
I think it's probably good advice. We got time for one more question.
Hi, thanks for being here. So Kayla and I, we're from Truck Brands, and we're a brand house in Canada. We're proud Canadians, but being here, we saw that the cannabis culture here is just way beyond anything we could have ever imagined. And I'm just wondering, as we're looking at entering the U.S. market, California is on top of the list, and if you've helped other brands cross-border, and if so, what are some of the top challenges?
Sure, I can respond to that. Yes, that we work with a number of Canadian brands and companies, as well as companies from other countries. Establishing some kind of U.S. presence, is, to the extent that it's plant touching, is probably going to be key. It is a cannabis company, there may be some issues with cross-border financial transactions. So most of the Canadian companies that are operating here have chosen to set up a U.S. affiliate and bank their cannabis money in this country and keep it here until the laws are more permissive. Citizenship is also an issue. California doesn't specifically require U.S. citizenship to be an owner, but they do require that owners submit background checks, which is a U.S. DOJ function. A lot of companies have chosen to partner with trusted folks who are U.S. citizens. This also, is good from an immigration perspective if you have those issues. So those are just a couple of considerations, but there are many brands from international brands operating in California. California is an innovative state. It's a technology leader globally, and it's a lot more welcoming to those sorts of participants in the industry than most states. A lot of states that have legal cannabis have very restrictive laws about ownership and public money ownership, all sorts of things. So folks complaining in California about the disclosures and financial interest holder requirements should be aware that even though California is requiring a lot of disclosure, it's actually a quite open environment in terms of who they're welcoming to come in. I don't know if anybody wants to add to that.
All of that is spot on. I think all four of us have probably helped brands come in from various countries, including Canada. One other thing I would point out, and I'm sure Cassia would agree, is take a look at the IP landscape. What is it that you're bringing into the States to the extent that it is a brand? You're going to want to take a look at the IP landscape and navigate that before you get started. That's another element.
Thank you, guys. That's going to wrap up our panel on creating a brand. Yeah, please join me in a round of applause. Thank you to Cassia, Tom, and Sahar, and enjoy the rest of the show, guys. Thank you.
So much.
Thanks,
Thank you.
everyone.